And we are set today, you may have a seat. We are set today for a plea and sentence. I know we tried this back on the 22nd, and some questions came up, in particular, the possibility of double jeopardy. I have reviewed and done my own research. I don't believe that applies here, but I'll leave it up to counsel to argue otherwise if they feel as though that's necessary. Mr. Hartel?
I don't feel additional allocution on that is necessary, Your Honor.
Ms. Carey?
Nor do I.
All right. So it's my understanding we have a plea agreement in the
A no contest plea means the person isn't admitting the crime, but also isn't denying it. It's often used as a strategy to avoid bigger problems later, especially if there might be a civil lawsuit.
Case. And my understanding is that the defendant will plead no contest to all counts as charged. Is that correct?
Yeah.
That would be the understanding.
All right. Ms. Carey, I believe I returned your exhibit last time we were here. Actually, I think Mr. Carnes was covering you. Do you have that? Mr. Moore, while she's looking for that, will you please raise your right hand? You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. It's my understanding then that you'll be pleading no contest to all counts 1 through 4. Count number 1 being computers using a crime to commit an offense with a maximum imprisonment of 1 year or less. That is a 1-year misdemeanor and or a $5,000 fine, reimbursement to the government for expenses incurred, and consecutive sentencing may be imposed for the underlying conviction. In count number 2, you'll plead no contest to telecommunications malicious use. Regarding Ms. Carla Filkins, that is a 6-month misdemeanor and or a fine of $1,000. In count number 3, you'd plead no contest to telecommunications services malicious use. Regarding Marcus Pesha, that is a 6-month misdemeanor and or a fine of $1,000. And then in count number 4, it is alleged, or I'm sorry, you would plead no contest to telecommunications malicious use in regards to Renee Pesha. That again is a 6-month misdemeanor and or a fine of $1,000. Is that your understanding of how the case will be resolved today?
If I may, Your Honor, just to reiterate, there's also the agreement that the other cases would not be pursued.
Correct. Thank you for that. And so
this is where plea deals get interesting. The state agrees not to go after the other related cases. It's a big trade-off. In simple terms, plead guilty to these charges, and the rest will be dropped.
Additionally, there will be no charges arising out of the Wexford County Police Report 83-25-00625 or the City of Cadillac Police Report. Ms. Carey, do you have that number? It ran into other letters on my sheet, and I can't read what it says. I know it's a 25, I want to say 804 maybe? 884.
It's the same. It would have been one.
Okay, so it all arises out of the same occurrence?
Correct.
All right. Mr. Moore, is that now your understanding of the plea agreement?
Yes, sir.
And is that a full and accurate recitation of the plea agreement?
Yes, sir.
And I know we went through this last time, but I still need to cover it today. Did you read and sign the advice of rights form, talked about your rights to an attorney and your rights to a trial?
I did, yes, sir.
Did you understand those rights?
Yes, sir.
And do you understand that by entering a no contest plea today, you'll be waiving those rights and you won't have a trial of any kind?
Yes, sir.
Has anybody promised you anything in order to get you to plea today other than the agreement?
No, sir.
Has anybody threatened you in order to get you to plea?
No, sir.
And is it your own free choice to plea today?
Yes, sir.
Now, do you understand that by entering a no contest plea, that it will allow the court to review in this case, a police report, which was already admitted as People's Exhibit number 1. I'll be able to use that to determine whether or not there's a factual basis and whether or not, and to use that for sentencing purposes. Do you understand that?
Yes, sir.
Additionally, the reason for the no contest plea is
the judge explains that a no contest plea can help the defendant if he gets sued later. It might be a smart move, but it also means admitting the court has enough evidence to convict without actually saying guilty.
Potential civil liability. So if any person's listed in the complaint decides that they want to sue you civilly, a guilty plea could be used against you. This would allow you to accept the responsibility as if you are guilty without saying you're guilty. Do you understand that?
Understood, yes, sir.
Then to the allegation that on or about January 21st, 2025, here in the city of Cadillac in Wexford County, in count number 1, that you did use a computer to commit a crime with a maximum imprisonment of 1 year or less, in particular, malicious use of a telecommunications device. How do you plead?
No contest.
To count number 2, malicious use of a telecommunications services in regards to Carla Filkins. How do you plead?
No contest.
In count number 3, malicious use of a telecommunications services in regard to Marcus Pescia. How do you plead?
No contest.
And in count number 4, malicious use of telecommunications services in regards to Renee Pescia. How do you plead?
No contest.
Last time we were here, I had the opportunity to review People's Exhibit number 1. Counsel, do you believe that People's Exhibit number 1 forms a factual basis in which to accept the plea,
I do.
Yes, Your Honor.
and that the court rules have been complied with?
Yes, sir.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. In particular, Mr. Moore, I find that back on January 21st of this year, you had sent messages, and those messages were threatening in nature. I'm sorry, People's Exhibit number 1 also includes the Michigan Department of State Police incident number 6441025. In particular, to the message that was sent to Ms. Filkins, it states as follows: "You're going to do something about the water in Cadillac."
Now we're seeing the real Facebook messages, and they are ugly. This isn't just an argument, it's violent threats, the kind that turn a keyboard into a weapon.
Or what, you stupid, dumb bitch. You'll be lucky if one scary night someone don't come to your home and pull you from your sleep and pull you to the streets and put a bullet in your head, you corrupt, dumb bitch. Additionally, there was a message sent to Mr. Pescia that says, "Just seen your wife reporting city council meetings on Facebook. You, sir, and your dumb little bitch of a wife should be pulled from your house while you sleep and a bullet put in your head. You're scumbag, corrupt loser, bitch who should be shot dead in front of the whole community of Cadillac just to show an example. Your wife is a scumbag, corrupt loser, or bitch too, you stupid fat fuck." I apologize for the language that was used, but I believe it's appropriate to place that language on the record to get the defendant's full intent when sending those messages. It's also my belief, based on the reading of the reports, that those had come in through a Facebook Messenger, which would meet the requirements for use of a computer to commit the crime. And additionally, I also find that these messages were sent to or regarding all persons involved, and that all persons involved would have seen these messages, and that they were sent with the intent to terrorize, frighten, intimidate, harass, or disturb the peace of each of these individuals. Additionally, I find that based on my reading of the report and by defendant's own admission, let me just find this here. He also admits to sending the messages and classifies them as an emotional overreaction, but had no plan to follow through with the threats. While he had no plan to follow through with the threats, at least as he describes, I do find that based on recent case law arising out of the Michigan Court of Appeals and the Michigan Supreme Court, I believe that these messages do show the intent of sending the messages was to threaten, terrorize, harass these individuals, and that the defendant knew that when sending those messages, that is the effect that they would have. As such, Mr. Moore, I find you guilty in count number 1 of using a computer to commit a crime with a maximum imprisonment of 1 year, which is a telecommunications services malicious use. Count number 2, telecommunications services malicious use regarding Ms. Filkins. Count 3, telecommunications malicious use regarding Marcus Pescia. And count 4, telecommunications malicious use regarding Renee Pescia. I also find that the interests of justice are well served in allowing the defendant to enter a no contest plea, in that a guilty plea could be used against him in a potential civil liability case. I also find that the plea is knowing, voluntary, and accurate. Pursuant to the plea agreement, those additional cases will not be brought. Ms. Carey, are we able to sentence today?
We are, and I have 2 of the victims here who would like to speak.
All right. Who wants to go first? Mr. Pescia, could you just state your name for the record, please?
Marcus Pescia.
And what is it you would like the court to know?
Thank you, and good afternoon, Your Honor, and officials of the court. Your Honor, words have meaning. Words can be weaponized.
The first victim's statement hits hard, showing how dangerous words can be. That's why prosecutors take written threats so seriously. Once they are out, you can't control how far they spread or who might act on them.
And words have consequences. You're here today because Mr. Moore read words on a social media platform posted by people that, in my opinion, was published to create an environment rife with chaos and mayhem, an environment to facilitate a crisis that does not exist by the malicious spreading of lies, misinformation, and attacks on my and my wife's character and credibility. Words have meaning. They can be weaponized, and they do have consequences. Mr. Moore could have read those words and reached out through a variety of methods to contact me, or a member of my staff, or a member of any number of state agencies, or even the feds, to gain information. Information that would provide the factual truth of what was being, in my opinion, falsely propagated on social media. However, Mr. Moore did not reach out to learn the truth. Rather, Mr. Moore directly messaged me on the social media platform's messaging feature to threaten me and my wife. And further, as I understand, also posted his profoundly alarming and disgusting threats in at least one publicly available social media group for an unlimited number of people to see, share, and spread. All things that could have led to, and still could lead to, disturbingly violent outcomes. Mr. Moore's actions have detrimentally impacted my life and my wife's. Mr. Moore's actions have also had a negative effect on my children, my family, my friends, and even colleagues. Mr. Moore's actions have caused stress, anxiety, and an emotional roller coaster of feelings. The shock and horror to see words about my wife and I being drug out of bed in the middle of the night, dragged through the streets, shot in the head, and displayed in the town square are evil, and they do have an impact. Stress, sleepless nights, being on edge, they're still with me. They're still with my wife and others. Behavior Mr. Moore has exemplified, it needs to stop. It is not okay, nor is it something that can be simply forgotten, forgiven, or excused. Words have meaning, words can be weaponized, and words have consequences, and I appreciate the court's time. Thank you.
Thank you. Ms. Filkins?
Good afternoon, Your Honor and officials of the court. I came today not with a prepared statement, but I would like to speak from the heart today.
The second victim makes it clear, social media may allow free speech, but when words turn into threats against public officials, it becomes a crime.
Words do matter, and Jamie Moore chose to use his words for harm and for evil. And that impacted my family, my 85-year-old mother, my son, who is a Marine, my other children, my grandchildren. It impacted me. It was a game changer for me. I served the city of Cadillac for 11 years with tremendous honor. But when I received a death threat for caring for my community over things that Mr. Moore read on Facebook and other social media that weren't necessarily true, people were just putting their words out there because that's what they can do on social media. And on January 21st, the very first thing before I walked out of the house that morning, I received that message from Mr. Moore on Facebook chat. And I was terrified. I called my husband home. I called the public safety director, and we spent the rest of the day not planning for our business that we needed to conduct that evening for the city of Cadillac. We spent our day trying to, first of all, understand what was happening. And how could we take care of our community with these types of threats coming forward to us? It wasn't just about us. It was about people that are out there that can do such horrendous things with their words. And I just want the court to understand what that's done. Thank you.
Thank you, Phil. Elocution, Mr. Hartel?
Yes.
Well, first of all, I had ordered a pre-sentence investigation report on this. Did both parties receive that?
I did.
Mr. Hartel?
I did as well, Your Honor.
All right. Elocution?
Yes, thank you, Your Honor. Anytime there's a civil liability possibility for the no contest, I'm obviously a bit cautious to overly allocate. However, I have had discussions with my client quite a bit about the situation. I would ask the court to equally factor in the goals of whatever punishment is given today. I believe that with supervision, any concerns the court may have for education of my clients, for public safety, can be incorporated into terms of that probation. I realize that recommendation for a jail sentence was in the PSI, and the reasoning was explained in there as well. I certainly ask the court not to give a higher amount than was recommended in the PSI. I realize the court could, but I would ask the court still to consider just probation in this situation. I believe my client has done well on bond. I know there was some concerns that the people had mentioned that were being dismissed as part of this plea. We have our own position on whether he was or was not guilty of those particular things. I'm glad they're dismissed. You don't have to worry about it. My point is, he's always come to court. He reported to the PSI on time. He's a hardworking individual. In fact, I'm very proud to be able to say this part because I was proud of him when I saw it. He came straight from work to that PSI interview. He lives in Roscommon. He was still wearing paint-covered pants and other clothing covered in work materials. He was a bit embarrassed. He didn't want to shake my hand. And I thank him for not getting me covered in paint, but he's that dedicated both to doing what the court needs him to do and providing for his family, being a hardworking, productive member of society. I have no idea if the underlying inflammatory situations were true or not. I know there were some statements about that as far as concerns in the community for what may have sparked the exchanges, but that's not what we're here for today. We're here because of the plea that was taken. And I would ask the court to factor in the factual basis with the no contest included the part where my client told law enforcement that he did not have the intent to actually follow through. I realize that doesn't change.
The defense lawyer admits the client was wrong but argues there was no plan to act on it. In law though, intent isn't just about actions, It's also about the impact the words are likely to have.
There was enough elements to meet the factual basis for the plea that was taken. But stuff is on a scale. If somebody authentically was trying to harm people, I don't doubt that that would be something the court should additionally factor in. I just asked the court to factor in. That does not appear to have been the case here for the appropriate amount of weight for that. My client has made a written statement that he would like to say to the court when the time is appropriate. I went over it with him. I believe it's appropriate for him to say to the court. He does have family here for moral support. They have been supportive of him throughout these procedures. I don't doubt they would support him no matter what the court does for punishment, but I know he wants to be there for his wife. He wants to continue to maintain that business. And he has a few other positives that he would like to say to the court. And again, I made sure that they don't destroy the purpose of the no contest.
Thank you. Ms. Carey?
He was authentically trying to harm, and he did. Mr. Pesha and Ms. Wilkins were harmed by that. Their families were harmed by that. As they told me, the community was harmed by that. They had to have extra law enforcement that day, work overtime, and come into work to make sure that they were safe. The city council meeting was canceled, and they had to have extra law enforcement present at those meetings because of this. Ms. Wilkins said this was a game changer for her. Words do have meaning, and his words were awful. He chose to use awful words to make and did make these people feel threatened, and they still are affected by it. When they receive those, they don't know what his intent is, that he didn't intend to follow through, or that he didn't use the word I as noted in the PSI. They don't know that. What they do know is someone wants them drug out of the house and with a bullet put in their heads. Mr. Pesha's wife said, that's not okay. And it does incite fear. And it's a threat. And it's horrifying, frankly. No matter what the reason or the underlying reason is, or the politics or whatever, that's not an appropriate response. So the people, I appreciate the department's or the probation department's recommendation for 93 days jail with credit for one. I don't think that rehabilitation is appropriate. Again, like the last case, I don't know what the rehabilitation would be. There's no alcohol or drugs alleged. So people are going to ask for a jail sentence on count one. The people are going to ask for 1 year and the 6 months in the other 3 counts. Thank you.
Mr. Moore, you have the right to address the court before sentencing. I do realize you've entered a no contest plea, but is there anything you would like me to know?
I would just like to make a statement to the prosecutor, if that's okay.
Direct it to me though, but I mean, look at me while you're doing it, but you can make your statement.
Yeah, you're right. I don't disagree. What I said was wrong. The position I'm in is absolutely ridiculous. It's uncalled for. There are no excuses. I fell short being a man, being an appropriate member of society, and it's pathetic to say the least. Whatever sentence imposed here today will be met with peace and understanding. And I sincerely apologize to those involved, to the courts for the taxpayers' dollars being spent on the proceedings. Thank you.
Thank you. Mr. Moore.
The judge is ready to give the sentence, but first he points out the toxic mix of online echo chambers and keyboard warriors. This case isn't just about one man, it's a warning about a larger national problem.
I want you to know that while I blame you for your actions, I don't blame you entirely. There is a whole fraction on Facebook that is driving this debate and they are doing nothing but fueling the fire, throwing allegations out there. I don't know if they're true. I don't know if they're not true. That's not for me to decide. But their actions on Facebook, and you are the perfect example, have created such a divisiveness in this community that I am almost afraid to admit that I am from, afraid's not the right word, ashamed to admit that I am from the city of Cadillac. I have lived here with the exception of 4 years my entire life. I am 5th generation of Wexford County. So for those that I refer to as the keyboard warriors who are out there throwing this stuff out there, shame on them, but also shame on you for biting the bait and doing what you did. I have not seen such animosity in this country with our elected and public officials for as long as I can remember, and as near as I can tell. I'm not even sure we've had it since the beginning of the country, when we used to drag people out and tar and feather them. That is what this reminds me of, and it has got to stop. This is completely ridiculous. It is hard enough to get people to step up to the plate and say, yes, I want to serve. I have been in the position that the two people that spoke today have been in as far as receiving the threats. I've been in that position where I've had to explain to my kids, I'm sorry, you can't go someplace. Or if you go, you need to be on the lookout because some crazy person has decided they're going to post a threat. Well, I don't take my personal experiences into sentencing. I just want you to know that that is the impact that this is having. It is so easy for people on Facebook to just say what they want to say with absolutely no consequence. But unfortunately, or fortunately, depending on how you look at it, you have a consequence because you took it to the next level. And if you think about it, if the people who are putting this stuff on Facebook caused you to post what you posted, the next logical step.
And here's the point, the judge links online threats directly to real-world violence. This isn't a maybe, it has happened before, and it never ends well.
Is that your post was going to make somebody follow through with your threats. Just follow the trail. And that's where this was going to wind up. Thankfully, that didn't happen. We have become so accustomed, and you know, there's an old saying that your rights end where my nose begins. Everybody has the right to free speech, but you don't have the right to do what you did. It used to be that people could say what they thought in the privacy of their own homes or amongst friends. But now with social media, that has gone so much further, and people state which would normally be in public or in private conversations, they publish it for the entire world to see. Thousands and thousands of people see these messages, and thousands of people act on them. January 6th is the perfect example of that. But for the grace of God, nobody saw your message and acted with it. I have also read the pre-sentence investigation report that I had ordered. And what I've learned from that is, while you state here today that you take responsibility for your actions, what I've seen in the past, or at least how I interpret that, is that you didn't take actions for your previous incidents. The one you blamed on basically a corrupt law enforcement, and that's why you were charged with domestic violence. The fact remains that case was resolved with domestic violence. I don't know if you pled. I don't know if you were tried. But the fact remains you were found guilty of that, regardless of whether or not there may have been a corrupt judicial system in the process. I have to agree with Ms. Carey. I'm not sure what benefit I get or that the community gets for putting you on probation. What I do know is that by locking you up, that is the only way I am going to protect society and at least protect you from posting these types of messages. I understand that they may have been posted in the heat of the moment, but as has been the theme this afternoon, actions have consequences. And there is no excuse for the actions that you took the time to type out and not just post it on a group, but you sent it to individual people. That took thought. You had to go out and type in those names to send them through Messenger. You would have had to have typed at least 2, maybe 3 messages in order to do that. That's not something that was just decided on a whim and I'm going to post my thoughts. That took thought. I realize the recommendation in this case from the probation department is for a 93-day jail sentence.
The judge gives 365 days in jail on the main charge and the maximum on the others, all running at the same time. It shows the judge isn't taking chances and thinks you would do this again.
With 1-day credit, I don't believe I can keep the public safe with 93 days. As such, I impose the following sentences. For count number 1, using a computer to commit a crime for a misdemeanor of 1 year or less, I sentence you to 365 days. In counts 2, 3, and 4, those have a maximum of 6 months. I sentence you to the maximum. Those are to run concurrent with each other. And on each of those sentences, you will receive 1-day credit. There is also a $75 crime victims' rights fee, a $50 state minimum fee, $150 fine, I'm going to change that. I'm going to do a $300 fine on count number 1. Away the fines on the other costs, other counts. There will be a $150 court fee, $150 attorney fee, the 365 and the 180 respectively with the 1-day credit. Mr. Moore, I hope you use this time to contemplate your actions, understand that your
In today's world of instant posts and comment sections, the line between free speech and a criminal threat is thinner than most people think. This defendant just learned the hard way where that line is.
actions have meaning. And I also hope you don't use this time to fuel the fire, so to speak. And when you get out, go on a rampage. I'm not saying that you will. I just hope that you don't do that. Because jail hasn't been imposed, you have the right to appeal that decision. If you decide that you want to appeal that decision and cannot afford an attorney to assist you in that regard, you have 14 days to request the appointment of an attorney from the court. Additionally, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. Do you understand that?
Yes, sir.
Do you have any questions for me?
No, sir.
Ms. Carey, anything further?
No, thank you.
Mr. Hartel?
No, thank you.
All right, we're adjourned on that case.